Hello and welcome to Let's Be Honest with your host, Just Johnda. Tonight I have another Just Johnda's LBD, also known as our legal breakdown. We're going to get into the lawsuit involving the former CEO of Abercrombie and Fitch. And it's so crazy because I really planned to go a little bit lighter before we went dark again this week because as usual there's Diddy stuff coming down the pike. I mean, New York has been keeping us busy. His attorneys have been keeping everyone busy. And well, we're just going to put that on the shelf because we are here to talk about Mike Jeffries. And again, we'll get into some other stuff in the next episode, which will be in a day or two. But right now, we are going to jump right into this because we've got a lot to discuss. And as you know, when you come here, I want to make sure that we have the smartest folks that are on social media because you are getting it from your girl, Just Johnda, and I'm also giving you some of the law with a lot of me. So let's go in. For those who are watching on YouTube, please like, comment, subscribe. Those who are listening on the pod, definitely subscribe. I want to see your comments, give feedback. Let's get into it. Give me one quick second. I'm going to make sure that this is being shared on the FNDD on Facebook because you all can watch this there as well, or at least click to it. And so I'm going to jump right in because we have an indictment that is coming out of the Eastern District of New York, as well as as well as the press release. I'm not going to bother playing the press conference. You could go on Reuters and watch that. Because the press conference was about 20 minutes long. It was interesting, but that's not what you tuned in for. If you want to see the press conference, you know where to find it. So let's get right into the initial press release that had everybody going, wait, it's finally happening. And also a bit of background from me because I've sort of watched this unfold. You all know I love my pop culture. I love all the good, the bad, and the ugly. And so I watched the BBC documentary. I can't remember the name of it right now, but something like The Dark Side of Abercrombie. And there has been lots of rumors, innuendo, threats of lawsuits, and articles written about this situation. So, for those of you who have been following this story a bit, it's actually not new. But I'm going to pull up the press release. We're going to go through the press release and then we're going to jump right in to the indictment. Okay, so I'm going to share my screen so that you at least see. And like I said, this came out of the Eastern District of New York, so they have been very busy. So here's the press release. Former CEO of Abercrombie and Fitch and two other individuals charged with, again, this is for YouTube purposes, we're going to call it SX trafficking and interstate prostitution. And if you've been listening to me, you know why we're saying it that way. Okay, now the defendants in this case, they jump right in and tell you that they allegedly arranged for dozens of men to travel to New York and hotels around the world for these events. A 16-count indictment was unsealed today in federal court in Central Islip, charging former Abercrombie and Fitch Co. Chief Executive Officer Michael Jeffries, along with Matthew Smith and James Jacobson, with SX trafficking and engaging in interstate prostitution. The indictment alleges that between December 2008 and March 2015, Jeffries, Smith, and Jacobson used a combination of force, fraud, and coercion to traffic men while operating I'm just going to say it, while operating a prostitution enterprise. All three defendants were arrested this morning. And so this was yesterday. So Tuesday, October 22nd. Excuse me. So Jeffries and Smith is Jeffries' partner, so that would account for why they were together, are scheduled to make their initial appearances and they did, on Tuesday afternoon in federal court in the Southern District of Florida. And Jacobson, the associate, appeared. It made his initial appearance in St. Paul, Minnesota. And they're going to be arraigned in the Eastern District of New York at a later date. From my understanding, that arraignment could come as early as Thursday, October 25th. But since they're on bond, maybe not. Breon Peace, United States Attorney for the Eastern District of New York, James Dennehy, Assistant Director in charge of New York Field Office of the FBI, and Thomas G. Donlin, Interim Commissioner, New York City Police Department, announced the arrest and charges. And you'll see them all there if you watch the press conference as well. So these individuals were all there. This was a joint task force involved once again, as we've seen in several of the more recent cases. As alleged in the indictment, and this is a quote, former CEO of Abercrombie, Michael Jeffries, his partner Matthew Smith, and their recruiter, James Jacobson, used their money and influence to prey on vulnerable men for their own sexual gratification. And we're going to get into what makes them vulnerable under this definition once we get into the indictment itself, because that's where we're going to dive deeper into the definition of coercion and what that means. Because I know there's going to be people like, well, they were men, they were grown. How is this? What does that mean? And so we definitely are going to get into that, because we know that people have interesting ideas, and rather antiquated ones as well, as it relates to whether or not something is coercion or force, particularly when it comes to men. Okay, so we talked about influence to prey on vulnerable men for their own sexual gratification. Today's arrests show that my office and our law enforcement partners will not rest until anyone who engages in sex trafficking or interstate prostitution, regardless of their wealth or power, is brought to justice. Mr. Peace expressed his thanks to the FBI Miami field office, and we saw that. Thank you for helping do your part and all of that. We saw that. Okay. Today's indictment highlights the alleged abhorrent behavior of Michael Jeffries. I love the word abhor or abhorrent, one of my favorites, of Michael Jeffries, Matthew Smith, and James Jacobson. The defendants allegedly preyed on the hopes and dreams of their victims. That's where we get into the coercion. Their victims by exploiting, abusing, and silencing them to fulfill their own desires with insidious secret intentions. This case is yet another example of individuals using their wealth, power, or reputation to manipulate and control others for their personal gratification. The FBI and our partners won't allow these criminal acts to go unchecked. We remain committed to investigating and bringing these cases forward to prosecution. Sex trafficking remains a pressing issue nationwide, and New York City is no exception. And just a little point of information, it's sort of that Northeast to Mid-Atlantic corridor is huge. It is one of the most pervasive areas for sex trafficking, which also makes it unsafe for young people, young boys and girls, because a lot of this sex trafficking, it's not was well, we'll get into it whether or not there's allegations of minors in this case, but typically outside of this case, just speaking generally as it relates to minors, it can be very dangerous, because that corridor I've gone to seminars on it, particularly in 2016 during the Democratic National Convention. I went to several sessions that talked about it because it's such a huge issue. So, at any rate, we're that's just a little bit of point of information. Okay, for those of you who are in the room, please like, comment, subscribe, and definitely comment, because in between reading, I am going to be looking at the comments so that I can answer your questions if you have any. Okay. Through our continued partnership with the FBI and the U.S. Attorney for the Eastern District of New York, the NYPD is able to enhance our investigations and secure convictions. Importantly, our close collaboration also allows us to connect survivors of this abhorrent crime with necessary support and the services that they deserve. From approximately 1992 to 2014. So they're looking at, well, there's a couple of time periods they're looking at. Both are fine as it relates to the statute of limitations because of the way that they're charging it. But the first part, they're just giving you his history with the company. From approximately 1992 to 2014, Jeffries was CEO of Abercrombie, a fashion clothing retailer that owned and operated retail stores around the world. Smith was Jeffries' life partner. The indictment alleges that Jacobson was employed by Jeffries and Smith, excuse me, to recruit, interview, and hire men to perform commercial sex acts for Jeffries and Smith. Now, 1992 to 2014, first of all, he was with that company for a very long time. We're talking 22 years that this person was with the company. So while the time period they allege, there's a reason for that. Typically, obviously there's statute of limitations issues, because there's no way that if there's any truth to the level of depravity that went on here, and we all saw that very soft, porny kind of advertisements that Abercrombie would do with, this super white, almost Aryan nation like young men with their chest out in these pouty poses, like, you see him in a shopping mall. It was ridiculous. Okay, don't laugh at my goofy Abercrombie poses. But so we know what was going on here. It was definitely a look, and that era with that look went on for a very long time. As set forth in the indictment, from approximately 2008 to 2015, Jeffrey Smith and Jacobson, together with others, operated an international sex trafficking and prostitution enterprise. Jeffries and Smith not only relied on their financial resources and Jeffries' power as CEO of Abercrombie. Bringing up Abercrombie a lot is going to be very important for the civil cases because we know that they're coming. But also on numerous others, including Jacobson and a network of employees, contractors, and security professionals to operate this venture, which was dedicated to fulfilling their sexual desires. So let me make that clear because I kind of talked in the middle of that sentence. Bottom line is they are saying that Jeffries and Smith, the partners, that they use their financial resources combined with Jeffries' power to get numerous other people, including Jacobson, who is the main third in this situation, but also other people, employees, security contractors, and all of these other people to be able to continue this enterprise. Now, they aren't charging him under RICO, but it is interesting because we're hearing this words like enterprise and all of these individuals working together. And when we talked about RICO, there's usually people that are kind of working for this common evil, is like the evil empire. But who knows? Maybe there'll be a superseding indictment, or they could simply just be focused on this and don't want to muddy it up with having to prove all of the other elements that go into RICO, although you have the underlying charges, but okay, not gonna beat that dead horse. Okay, as further alleged in the indictment, which we're going to get into in detail in a few moments, Jeffries and Smith paid for dozens of men to travel within the United States and internationally to various locations, including the Hamptons, New York City, hotels in England, France, Italy, Monaco, and St. Bart's, for the purpose of engaging in commercial sex acts with Jeffries, Smith, and others. So there's events. They had their own version of freak-offs. Jacobson allegedly traveled through the United States and internationally to recruit and interview men for the sex events. During tryouts of the potential candidates, Jacobson typically required that the candidates first engage in acts with him. The indictment alleges that Jeffrey Smith and Jacobson used coercive, fraudulent, and deceptive tactics in connection with their sex trafficking prostitution venture. For example, among other things, they employed a referral system, an interview process that did not inform the men of the details. This part is very important because a lot of people are definitely going to say, well, they went, they took the trips, they got whatever money involved in all of that. So this first sentence here is very important when you talk about individuals not being informed of the details. Yes, I took the flight because I thought you wanted me to be an Abercrombie model. I came to the parties. I may have flirted. I may have kind of entertained your advances because, it's obvious that you thought I was hot, but that is still not the same thing as you knowingly and fully intending, and I'm saying you as in Jeffries, Jacobs, Smith, and Jacobson, that is still a very different thing than those individuals fully knowing from the gate when they recruited them and interviewed them, or the guys were referred to them, that their intention from the very beginning was to use them for these, as they're called here, sex events or other types of sexual activity, or that they would be required to do those things. That piece, what you told them and what you didn't, very, very important. All of it's important, but that piece is pivotal to a lot of this, especially if this ends up in front of a jury who is going to potentially have a natural bias because they're men, and also because there was this very sort of soft sexual kind of gauzy Vaseline light. I don't mean Vaseline light, but sort of this hazy Vaseline over the camera lens. Just this undercurrent of sex and sexuality as it relates to the whole Abercrombie model piece, the whole metro aspect of it, and then the fact that there is homosexual activity, which is also again bringing people's potential natural biases to this. You have to really establish from the outset issues of consent and the lack thereof. And when we get a little deeper in this, I think that some of the details they give about how these sex acts allegedly took place, even the physical mechanics of how they took place, while those details may not be easy on the ear to hear, and if there's any physical evidence, may not be easy to see, it is going to be key because there are these hoops of bias that are just naturally come with a case like this, and it's going to potentially come with a jury. So next, they caused the men to believe that attending the sex events could yield modeling opportunities with Abercrombie or otherwise benefit their careers. So this one is for those who did consent, because they want to be covered either way. So you have the first one that covers the lack of consent, but this one covers situations where there was consent. Okay, you asked me, I did it, and then you put me out to pasture. I hopped the flight. I had a feeling that, as the song says, it's about to go down. And it went down, and I did your little party. And then you're like, okay, done with you. Bye-bye. Caused men to believe that not complying with requests for certain acts during the sex events could harm their careers. This is the other piece of the coercion. So you see, you got several different kinds of behavior here, because these are the individuals where you kind of poked and prodded them, no pun intended, into doing it by saying, you're not going to have the job. You're not going to get the modeling gig. I'm going to ruin you in the business. I'm going to blackball you altogether if you don't do these things. And so then you have a case for the individuals who didn't go through with it because there was still the coercive behavior and the threatening behavior. And that feeds into bullet point number 2, because you caused them to believe that they had to do the stuff, they consented, and then the opportunities didn't come. So that one works for both the people who did go through with it and those who didn't. The fourth bullet point required men to relinquish their personal items, including clothing, wallets, and cellular phones, and store them in an inaccessible location during the sex events. This is another good one if the prosecution can, for the prosecution, if they can prove it, because again, this goes to it's simply that you trap these individuals. And of course, if you're trapping individuals, you're keeping them from seeking help or running away, then that underscores a case for potentially forcing people to either be places against their will or do things against their will, or both. Required men to sign non-disclosure agreements. Well, we knew that was going to happen. And then, of course, most people who sign them typically don't understand that non-disclosure agreements do not cover criminal behavior. But if you are in a vulnerable position, as in you are young, you're uninformed, you're in this situation where there has been this coercive, destructive, and scary behavior, you sign a non-disclosure agreement, and you actually believe that despite the fact that things were done to you that are probably illegal, that you're not supposed to say anything. And I say to people all the time, NDAs are only as good as the piece of paper they're on, because if the person abides by it, fine. Once they say something, okay, fine. You might be able to sue me, but I've still put your business in the street. On more than one occasion, when men did not or could not consent, Jeffries and Smith violated their bodily integrity by subjecting or continuing to subject them to invasive sexual and violent contact with body parts and other objects. We're going to get into that because there is, and it goes into the next one as well, because there is some allegations as it relates to drugs and injections and that type of thing. And the next bullet point mentions that briefly, but the indictment goes a little deeper. On more than one occasion, Jeffries and Smith directed others to inject or personally injected men with an erection-inducing substance for the purpose of causing the men to engage in sex acts the men were incapable or unwilling to engage in. Once we get into the indictment, when I really explain how insidious that allegation is, because there are allegations that you essentially render them incapable of fighting back because of the drug you give them. But since you still want to take advantage of their bodies, and unlike women, where erections aren't an issue, but with men, if you want to actually use, for one of a better way of putting it, their tool, you need it to work. Well, if you have rendered them nearly unconscious, then how is that going to happen? So very disturbing way the drugs were used, which we're going to get into shortly. Many of the victims, at least one of whom was as young as 19 years old, were financially vulnerable and inspired to become models in the fashion industry. So this is a casting couch situation. So let's call it what it is. In fact, even the U.S. attorney referred to it as that as well. I'm sorry, I'm shifting off camera. Okay, some victims recruited by the defendants had previously worked at Abercrombie stores and had modeled for Abercrombie. So they actually used the stores sort of as a feeder system, because if they worked at the store, then you just get them that way. If convicted of the sex trafficking charge, the defendants could each face a maximum sentence of life imprisonment, that's for the sex trafficking charge, and a mandatory minimum sentence of 15 years imprisonment. So just to be clear, a mandatory minimum sentence means that the judge can't suspend that. Nobody can suspend it. If you are convicted of that, you don't have to be sentenced to life. The charge goes up to life. You don't have to be sentenced to life. But whatever that sentence is, it can't be less than 15 years. So it could be 16 years. It could be 15 and a half years. But it's got to be a minimum of 15 just starting right out of the gate. If convicted of the interstate prostitution charges, the defendants face a maximum sentence of 20 years imprisonment. But let's be clear, it is per charge. Interstate prostitution carries 20 years per charge. They're charged 15 times with that. So even if they were to get 1 year on, let's say they were convicted of 5, judge gave them 1 year on each. It's 5 years because there's 15 of those charges. The charges in the indictment are allegations. The defendants are presumed innocent until proven guilty. We know that if you believe you're the victim of the crime. So they give more information. It's ongoing. They're seeking other victims. Now, Michael Jeffries, who a little scary looking, kind of crypt keepery, is actually 80 years old. His partner is 61. So he was not even a young man when these things were alleged to occur. Now, since they're not going back to 1992, I won't go back to 1992. We, of course, have our suspicions because, again, someone has these types of predilections. They don't just pop up, when you're 60. They don't just pop up 20 years into the game. But let's just work with the time period they're talking about. So if he's 80 now, and they're talking about 2008 to 2015, if he's 80 now, 2008, I guess it was about 16 years ago. Yes, it was 16 years ago. So he would have been 64, and his boo thing would have been about 44. So, it makes it appear that his boo, Mr. Smith, has been with him at least through the duration of these charges. So, we're talking about someone who was already moving into or well into dirty old man phase. And I'm not saying that 64 is old and decrepit. I'm saying that compared to these young men, 19, 20, 21, 22, yeah, you're the creepy old guy. And quite frankly, even his boo, who was 44, 40, 44, 45, again, to 19 and 20-year-olds, you're the creepy old guy. Jacobson, only 10 years younger than Jeffries, so well into his 50s. Yeah, still creepy old guy, but powerful creepy old guys. And of course, we know that's how creepy old guys tend to get away with stuff. Okay, so let's jump right into this indictment. So I'm going to switch screens for that. And we're going to jump right into, well, first, I'm going to give you a picture of this creepy old guy. And I'm going to be honest, he never looked much better than this. I mean, ew, never. So let's see, is this it? Yes. So just in case, this is Mike Jeffries. Clearly, whole lot of surgery going on. The older pictures, the I guess younger pictures aren't much better. This picture, I would imagine, based on more recent one I've seen, was probably about, I would say, about 10 years ago. So that is Mike Jeffries. So let's get into the indictment. A contract is a contract, even for sex work, I guess. Critical thinker, yeah. So you're right. Even for sex work, a contract is a contract. If you say you're going to put me on, put me on. And again, if they consented, but of course we're going to get deeper into while I'm talking to critical thinker, we're going to get deeper into what they consented to, because of course, as we know, there are cases, and we've seen them. There's one of a very famous athlete that I won't get into because folks will get mad, where she consented to one thing, but the reason the case came along is she didn't consent to everything. And even if you're like, okay, I'm down with hopping the flight and and us getting our freak on, where some of these people, the individuals who then found themselves on the receiving end of needles and all kinds of other stuff. Okay, so this is, as we know, I mentioned, this is in the Eastern District of New York. And let me just fix my screen a little bit so we can go over it. So right now, this is not a civil case. Now, 2 civil cases that we know of have already been filed. So probably by the weekend, I'll bring the civil cases on and we can talk about those, because as we know, those are going to get a lot deeper. This indictment is not super long. It is only 11 pages, but every prosecutor does their indictments differently in terms of length and level of detail. There are certain elements that always have to be in an indictment. You have to obviously state the charges, and you need to give some recitation of the facts to support the charges that you're bringing. And of course, what the law involved in those charges. However, not every prosecutor writes their indictment like a James Patterson novel. There are some, like Operation Varsity Blues, that indictment was 180 something pages of good reading. I'm actually going to go and bring that back. I have been saying for years that I was going to do an episode on Operation Varsity Blues, because in every documentary and everything that has ever come out about that, there are some key elements that are always glossed over. And when I do the episode on it and give you the perspective on that, especially when we talk about the cross-section of privilege and race and benefits and the Americans with Disabilities Act and all of those things in that, I think we're going to have quite an interesting discussion. But anyway, I digress. I bring that up to say that Not all prosecutors do it the same. This one kept his a bit more succinct. You get a good recitation of the facts, but they don't go chapter and verse giving you every gory detail about all 16 of the charges, but it's definitely enough to give us a picture as to why. Now, beyond that, you also don't have, which you see in civil cases, where Abercrombie or any of the subsidiaries or any of those individuals or parties, because this is not a civil case. This is a criminal case where individuals are charged. Their liberty is at stake. And so it is just those individuals that the grand jury brought an indictment back against. So those distinctions are very important, and I know a lot of people know that, but I always like to make certain distinctions when I do this because one, you never know who's listening, and two, given everything that's going on in the era that we are in, and I'm not in any way saying it to be negative because I do both criminal and civil law. Um, that a lot of that, especially in these high profile cases, there is a lot of um, there are a lot of civil lawsuits coming out of them. People tend to get very confused about, well, why is this in this case, but it's not talked about in that case? Well, why do they have certain rights in this case, but they're not but not in that case? So as we go through, because right now, in this case, is going to be no exception, there's a lot of concurrent litigation going on the civil side. It can get very confusing for those who are not in court every day. And I get it. It's a little nuts. Okay, so our defendants in this case, and of course, it's the United States of America versus Michael Jeffries, Matthew Smith, James T. Jacobson, also known as Jim Jake, Mrs. Cook, and Todd. Interesting. Love the names. Love the names. Very interesting. By the way, I suspect that the individuals in these cases are their attorneys are certainly going to move to sever these cases. They're going to move to make sure that I know that, well, maybe they won't, but I will say from my perspective, 20 years in the game, criminal defense attorney, I would not want my client tried with any of these individuals. If I'm James, so let's take James Jacobson. He's charged as the recruiter. If I'm James Jacobson, I don't want to be tried in the same trial as Michael and Matthew. If I'm James Jacobson and or rather, if I'm the attorney for James Jacobson, I am going to be immediately trying to, from a strategic standpoint, trying to shift my client's position in all of this. I mean, I'm still going to say he's not guilty of what he's accused of because, I mean, he could go to jail for life. But I am going to be trying to position him within the context of saying he's not guilty as well, as someone who was not on the same level as these two, because right now he's charged on the same level as these two, while arguably having a different role, still across the board on the same level. They all have the same charges. If I'm James Jacobson, or I'm sorry, if I'm the attorney for James Jacobson, I am saying James is not these guys. James is not the big money guy. He wasn't the CEO. He didn't have the big salary and the big position and the mansion and the access to the company jets and all of that. James at best is a friend, at worst an overzealous employee or consultant. That James was someone who was basically on the payroll in whatever position we can claim he was in, and of course that he tells me he was in, and that anything that he did, especially if you're saying that he recruited and interviewed people, that anything that he did within the context of a legitimate recruiter, as a legitimate human resources person, that yes, he may have scouted individuals that he felt fit the Abercrombie brand because they looked like models, they long chest and the abs and all of that. But that was because the brand required that. And when he interviewed people and recruited people and connected them with Jeffries and Smith, he did it with benevolent intentions of someone who was just setting people up for a job, having nothing to do with whatever Michael Jeffries and Matthew Smith's nefarious intentions were. My client, again, if I'm speaking from the standpoint of representing James Jacobson, my client, not them. My client's legit. And yeah, along the way, my client found out that they were up to something. But at that point, my client's a victim too, because at that point, he felt like he was in too deep. He was threatened. He was coerced. He was told that if you don't follow what we're doing, you'll be blackballed. This will happen to you. That will happen to you. James Jacobson, just someone who got in too deep. And then at that point, he just went along to get along, nowhere near the position of Michael Jeffries and Matthew Smith. Now, if I'm representing Matthew Smith, I'd be moving to sever his too. I am not the head of anything. I'm just his boyfriend, or I'm his life partner. I'm his life partner that is almost 20 years his junior. He's got more money than me, more connections than me, or whatever. And when these parties or events took place, I had no way of knowing that everybody who was partying with us, taking drugs with us, having sex with us, that they weren't down for the get down. How was I supposed to know that he was abusing his position and in cahoots with that Jacobson guy over there, setting these things up? I'm just at home waiting to get my freak on. You bring them to me, I'll roll with it. We hop in flights, I'll roll with it. I didn't set any of this up. I didn't even know it was a setup. That's my argument if I'm Matthew Smith. Michael Jeffries is just going to have to say, I didn't do it. I didn't do it. Any sex that I had with anyone was consensual. In fact, a lot of these individuals will admit that they got on the plane of their own accord. Everything that they did was of their own accord. The only thing that became a concern was, a couple of people may have had, when we had some party drugs, a couple of people may have done a little too much. They weren't experienced, and now they've got buyer's remorse. Not everybody becomes a superstar just because you open up your shirt and you pose and you pout for an Abercrombie ad. Doesn't mean that you're going to ultimately become Ashton Kutcher or Tyson Bedford. That's my defense. Not a great one, because he's old and creepy. Okay. So let me check the comments. Generally, how many? Okay, so we've got some questions here. Great. Thank you, Critical Thinker. Generally, how many layers are needed for a RICO systemic charge? Great question. You really don't need many layers. You really just need that connection. If you listen to some of my other things, when it comes to RICO, I call it a triangle. You need the person at the top, which in this case would be Michael Jeffries and arguably Matthew Smith. You need that layer going down the side, because everything's going up to the top, right? It's for the benefit of the enterprise, and the enterprise, because all of it is the enterprise, okay? And the person at the top is the head of the enterprise. It's who it's for the benefit for. Let's say if we're talking about the R. Kelly situation, that's a great example to use, especially when you're talking about sex cases. So you've got him at the top of the criminal enterprise. And what he wanted was sex and whatever other abusive behavior. So you had, on the one hand, you need to be able to prove, so this is the one arm, you need to be able to prove that there are these underlying acts that are taking place that are illegal. So that's the one part. And then the other part is the individuals who are aiding and working within the criminal enterprise to make in order to effectuate that. So let's say the underlying bad acts of that RICO charge are sex crimes. Well, you need sex crimes actually taking place, and you need individuals to facilitate that. And so, and then of course it all goes to the top. Now, in this case, if we're talking about it from the standpoint of RICO, and if you look at it and you look at the R. Kelly case or the Diddy case, if you take those same theories, arguably, they're still here. Because in both the R. Kelly case and the Diddy case, the goal, unlike the mafia, the goal wasn't money. The goal was the desires of the person at the top of the criminal enterprise. The goal was to make sure that that person was supplied with what they got. So you got the individuals working within it to make sure it happened. The conspiratorial piece, where you have these individuals who come together, because that's the piece I forgot. I'm sorry. You have this conspiratorial piece where it is understood that this is what we're doing. We are actually, because you got to have that meeting of the minds. We are actually doing this for the ultimate goal, which is this person at the top. This person at the top having their desires met, a la R. Kelly. And so we understand that that is what we're doing. And so we're doing all of these acts in order to make sure they happen. We are recruiting, we're putting people on flights, we're doing all of that. So then that's the one arm. So we're doing all the work. And then there's the bad stuff that actually does happen. And then, of course, all of that works for the benefit of the person at the center of the enterprise. Quite frankly, the way that this is described, that's kind of what it sounds like here. I think that ultimately the only difference here with not charging, and I think I mentioned this earlier, with not charging them under a RICO statute is they don't want to have to take that extra step. And I don't blame them, because my thing is, if you don't have to, why bother? They don't feel it necessary, and I don't either in this instance, to take that extra step of having to make the connections and saying that all of this was cohesive and that it was always to be, because that's the hardest part about RICO is making the jury understand that this was all for an enterprise. Because I always felt that one of the, in my opinion, one of the weakest parts, but I mean, the jury found him guilty anyway, of the R. Kelly case in terms of the criminal enterprise is that this person was an artist. He, he worked with lots of people and collaborated with a lot of people and whatever. So my argument was, and when I was looking at it was the criminal enterprise really the sex trafficking, or was the enterprise fame and keeping him famous? Was the enterprise really, because ultimately he did have a company. So, and so I think that when everything is not criminal and there is a combination of actual legitimate behavior and criminal behavior, it gets a little murky when you have to convince a jury of or make them understand that whole enterprise piece. So if you don't have to, and you have these charges that carry a shit ton of time, which these do, then you just don't. You just don't have to. You just have a straight line from, which, and we're going to get into this in a bit. You just have a straight line from the coercion and the other abusive acts, which we'll talk about in a few moments, to the person. Was in this case, was this person recruited in a manner that comports with the elements? And we're going to talk about the elements. Were they recruited? Were they trafficked? Were they taken to wherever they need to take? The sex doesn't have to take place, by the way. It doesn't have to be completed. You just need to do all the stuff leading up to that. Did that happen? We don't have to get into figuring out whether there's a stupid enterprise and all of that. Were the simple elements of the underlying charge met? Yes, the end. The end. In sex trafficking and international prosecution, especially since you are dealing with adults and not with kids, where it's easy, it's per se, if they're a minor, you could just be like, well, if they're a minor and you got them involved in this, then boom, you're done. But when you're dealing with cases like this involving adults, especially when individuals were not kidnapped off the streets. Now, once they had them, some may have been held against their will, but they weren't just snatched up off the streets. Most of them did go into the situation willingly. It just changed into something else once they got there. That is convoluted enough for a jury who is already coming from a society with a natural bias, especially given that these are men and there's homosexuality involved and all this other stuff. You don't need to try to add proving a criminal enterprise on top of it. You just simply don't have to. I know that was a long answer to a short question, but I enjoyed it. So I hope you did too. But do you need aliases to recruit regular workers? No, you don't need it. You don't need an alias at all. And I don't think that they use aliases. These individuals knew that the encounter was going to be, and I'm not even talking about sexual encounter, I mean, even just interviewing or whatever, was going to be with someone connected with Abercrombie, whether it was Jacobson, who apparently, according to the charges anyway, was the main recruiter. I don't think that he was involved in every single instance. I don't think that there was any issue of aliases here. The whole lore, which is going to help the civil cases for sure, the whole lore of this situation with these young men ultimately being, in sort of biting off more than they can chew, and no pun intended at all. I simply mean thinking they're going into one situation and ending up in another. The whole lore was the fact that this was Abercrombie and they wanted to be professional models. So no aliases needed and none used. In fact, very much openly saying, this is who we are, so that you could get the people. Okay, so we know who the three defendants are. We know that Michael Jeffries was the CEO of Abercrombie during the whole time that this situation allegedly occurred. He also had JFO, which was a family office that managed his personal income and assets. I think they're mentioning that obviously because they're going to talk about, when you get to the end, when you talk about forfeiture, you want to make sure that you hit everywhere where he has money. Matthew Smith was the romantic partner as well as an employee of JFO. which is his personal company. So, that may have just been because he was giving him an allowance or salary or whatever. In addition to managing assets, the JFO employed personnel who facilitated Jeffries and Smith's personal and social lives by, among other things, arranging their travel and managing their properties and financial affairs. So bottom line is they're trying to make it sound like he was some, fancy, he had some fancy position. And I'm sure he had a cool title working for JFO, but it also sounds like he basically did the same duties that a PA would do, but it happened to be his man. Who knows? Wouldn't be surprising if that's how he ended up with him in the first place. But we shall go on. The defendant, James T. Jacobson, also known as Jim Jake, Mrs. Cook, and Todd, was employed by Michael S. Jeffries and Matthew C. Smith to recruit, interview, and hire men to perform commercial sex acts for Jeffries and Smith, including at the New York properties. So this is alleging that he was employed specifically for this. But remember, if I'm James Jacobson, I'm saying, no, I was hired to work for them for JFO, or I was basically their guy Friday. I mean, these are people with, this man is a CEO of this huge international corporation. He's rich. He has money. He's got a ton of money in properties or whatever. He hired me to manage all of that. My job was not just going to find young men. And even if it was, ultimately, I was stuck between a rock and a hard place, because I think I'm interviewing and recruiting people to help him out for the stores. And then I find out something else is going on. Well, now I'm stuck in the middle of this mess. Again, if I'm the attorney for Jacobson, that's one of several things we're going with. All right. So the sex trafficking and prostitution business. So now we're just going to get into the facts, and then I'm going to give you some of the law, and then I'm going to let you go. Okay. So the sex trafficking and prostitution business, from approximately 2008 to 2015, the defendants, all three of them, together with others, operated an international sex trafficking and prostitution business. They make it sound so fancy and sexy when it's something so seedy and gross. During this period, Jeffries and Smith relied on their vast financial resources. Jeffries' power as the CEO of Abercrombie, and numerous people, including Jacobson, and a network of employees, contractors, security professionals, to run a business that was dedicated to fulfilling their sexual desires. You know what? That sentence, that paragraph is way too long, so I'm going to break it down to you. I'm not even going to finish it. The bottom line is, this first paragraph, paragraph 4, is basically alleging that Jeffries and Smith relied on several things. One, their vast resources, because Jeffries had a ton of money. He also had power because he was head of Abercrombie. And of course, this is Abercrombie, again, is all about the guys who are like this. Okay, head of Abercrombie. And of course, not only using his financial resources and just his overall position of power, kind of like Harvey Weinstein, super rich, but he's also extremely powerful, which makes a difference when you're trying to force people to do what you want them to do, and they're desperate to be in the business that you essentially gatekeep, given your power. So the bottom line is that they use the resources, the power of Abercrombie, Jacobson as a person, and any number of other employees, contractors, anybody else that they essentially needed in order to operate this international sex trafficking and prostitution business. So anybody that they needed to be able to make this happen, they did. And that they needed to make sure it was kept a secret. And most importantly, all of that helped to maintain his powerful position, as in Jeffries. As part of the international sex trafficking and prostitution business, and I'm going to stop saying that over and over, it gets redundant, as part of the business, the defendants, Michael and Matthew, paid for dozens of men, including, among other, John Doe's 1 through 15. So those are your 15 international prostitution charges. Individuals whose identities are known to the grand jury. So these individuals have already appeared in front of the grand jury, to travel within the United States and internationally to meet Jeffries and Smith in various locations, including at the New York properties as well as in hotels in such places as England, France, Italy, Morocco, and St. Bartholomew, for the purpose of engaging in commercial sex acts with Jeffrey Smith and others. Some of the men traveled to and were paid to attend multiple sex events. So this I want to explain, because this is where a lot of folks get tripped up, because they're like, why are they being charged with this when these individuals went willingly and they were paid? Well, simple. You can't transport people across state lines or internationally for the purpose of sex work. So even if the sex hadn't happened, if you make the agreement, you pay the money, and you go, because you have to do the acts in furtherance, so to speak. Well, not so to speak, that's what it's called. Then the crime has been committed. Now, would it be quite as serious? Would there be more consideration if things don't actually pan out? Possibly. Where this gets nasty, and we're going to it's coming, is that individuals got a little bit more than what was bargained for, as in Michael Jeffries and Matthew Smith, and allegedly Jacobson as well, got more than what they bargained for by force or by coercion. I have you here now. You agreed to come here for certain things. Now you're mine. There's also the piece where, so let's be clear, not every single person that traveled agreed. That's why I said some agreed that that's what they were traveling for or having the meetings for. Some of these individuals allegedly truly believed that they were there for the modeling and for the interviews and for the tryouts and all of those things, because those things do happen. And I think we have to remember and not pretend that people don't go to tryouts or to casting calls and all of those things. And in this case, and in many others, sometimes bad things happen. And just because they were guys and they were going to be, models with the goofy, Abercrombie faux seduction face, that doesn't mean that things couldn't have happened to them. And then, of course, when you get into the drugs and all of that, that's a whole other level in terms of what you wanted versus what you got. Or in this case, what Jeffries and Smith paid for versus what they allegedly took. Okay, so the defendants, Michael Jeffries, Matthew Smith, M&M, we're going to call them, through the JFO, recruited, hired, and paid an exclusive set of household staff to facilitate and supervise the events. So these weren't FOs like freak-offs, these were SEs called sex events. Among other things, the staff transported men to and from the SEs, arranged physical spaces for the SEs, and supervised the men who attended, including, among other things, facilitating the conduct described below in paragraphs 9 through 11. At the direction of M&M, the staff were present at, observed, and acted as security including controlling the entry and exit. So who got in, who got out. The staff also provided Jeffrey Smith and the men who attended with alcohol, muscle relaxants known as poppers. We've heard about poppers. Lubricant, Viagra, and condoms, among other things. And as directed by Jeffries and Smith, the staff also directed the men to, among other things, wear costumes, use toys, prepare or prepare for particular acts. Either the defendant Jacobson or the staff paid the men for attending. The defendant Jacobson traveled throughout the U.S. and internationally to recruit and interview men for the SEs. During the tryouts of potential candidates, he typically required the candidates first engage in commercial sex acts with him. Following the tryout with Jacobson, the defendant, Smith, approved the candidates prior to their selection for and transportation to an SE. At the direction of Smith and Jacobson, fees were paid. For those who, for also there were other recruiters, and so fees were paid to those individuals as well. And of course, again, these are all allegations. The defendants, M and Jacobson, and others acting at their direction, employed coercive, fraudulent, and deceptive tactics in connection with the recruitment, hiring, transportation, obtaining, maintaining, solicitation, and payment of the men to engage in the commercial sex. For example, Jeffries, Smith, and Jacobson, so M and J, and others, they had them do this. So now I'm going to get into it. One, A, employed a referral system and interview process that failed to inform the men of the details of the SEs. This is super important, because if you're going to say that people were okay with what was going down, if they're saying that they didn't know or they went under false pretenses, then your argument or your defense, using that as a defense, gets a little shaky. Now, of course, people will argue, okay, once you found out, then why didn't you leave? Well, we're going to get deeper into that as well. So some of these things are going to, now the connections as to why they are treating this so seriously are going to be made. Because let's face it, everybody knows this kind of stuff goes on all the time. But now, I mean, hello, all of these young broke heifers aren't going to Dubai because they suddenly had a windfall of cash or hit the lottery. How's Air Emirates getting paid for? So we know what time it is. But there's a reason, and now we're getting into them as to why they're going after them. Okay, so Section A, or subsection A, says they failed to inform the men of the details of the sex acts before they attended, including the full extent and nature of the sexual activity that would be required of the men at the events, including, among other things, anal intercourse and the insertion of large toys into that area, and high pressured enemas, all kinds of stuff. I hope I don't get flagged for this. Okay, next. I am just reading from the court documents. Next, because again, that's important. You want people to know that that's what's going to be required. Next, they required that prospective candidates first participate in an encounter or tryout with Jacobson, at times without advance notice. So you show up for your interview and he's like, okay, interview, talkie. Now, give me the goods, show me the goods, whatever. They caused the men to believe that attending the SEs would yield modeling opportunities with Abercrombie or otherwise benefit their careers, or in the alternative, that not complying. And this one is probably the one that is going to be more concerning with the cases, because when you talk about coercion, especially again with adults, especially if they're not being otherwise held against their will, then I told you, you either do this or, your career's over. Yeah, sexual harassment for sure. But uh, it, yeah, so if they caused them to believe that and they did it, then it's like business decision. I don't know. But no, it's all gross. I'm just messing around. So at any rate, but it is important when you get into the not complying, because the not complying is where other things come into play. You get into the real, where their SEs and FOs have some very interconnected. Not that they knew each other, and not that Jeffries parties and Diddy parties were conducted together. This guy sounds more like a Jeffrey Epstein, if anything. So Epstein, rather. Okay, let's see. Not complying with requests for certain acts during the SEs could harm their careers, including by, among other things, referring directly and indirectly to modeling opportunities that did not exist. Not cool. Incorporating Abercrombie products in the sex events, and providing men with the itineraries for SEs that did not refer to commercial sex acts. So I'm giving you an itinerary. I know that it's an SE. You don't. Problem. Red flag there. Well, there's many, but there's another one. And instead resembled those often sent to models for photo shoots. So you're giving these folks call sheets and they don't realize they're sexual call sheets, thereby obscuring the nature of the SEs from the men selected to attend. So, you go on America's Next Top Model, they give you the sheet that you think is going to have you, those episodes where they have them going on go-sees, running around all day. They give you the call sheet for your go-see where you're thinking you're going to go to one of these awful shoots where Tyra has you naked with a snake hanging by your hair from the ceiling. And instead, there are, there's Pasty Mike and his Matthew, and I guess Jacobson is probably there as well, and they're expecting you to get freak McNasty with them all up and through the house. Yeah, not cool. They physically groom the men prior to the SEs, including at times shaving their genitals without advance notice. Required them to relinquish their personal items. This one is certainly more problematic because it kind of reeks of you can't leave, including clothing, wallets, and cellular phones, and store them in an inaccessible location. Yeah, that's a little, yeah, that there's a lot that makes you feel skeevy reading this, or reading about what they're saying. But when individuals can't leave, or, well, I won't say they can't leave, but when you're taking things from them, including their clothes, wallets and cell phones are one thing. I mean, you just run down the street screaming and hopefully somebody stops and you use their phone. But your clothing as well, that definitely reeks of, it starts to get a little false imprisony there. Required men to sign non-disclosure agreements, which, among other things, prohibited their disclosure of information about the sex events, including to their own family, friends, and required the payment of damages. And again, as I talked about earlier, if you don't understand the intricacies of the law, especially as it relates to how this behavior could actually be criminal, or even better yet, which I'm sure was part of it, you, because of the fact that you win, and especially those who may have accepted money, kind of feel like, ugh, I sort of committed a crime myself, or maybe not committed a crime, but it definitely just won't look good that everybody knows I maybe taking money for sex, even if I did think it would help me become a model, then that's all the more incentive for you to just go along with the non-disclosure agreement. And intentionally recruited heterosexual men, certain of whom were unwilling to engage in particular sex acts, including, um, well, let's say certain sex acts that a lot of heterosexual men claim, that we'll have a whole other conversation a different day, that they don't want, and insisted that men who previously stated that they were unwilling to engage in particular sex acts, including that one, nonetheless engage in such acts during the SE. So essentially, recruiting hetero men for sex from behind, or rather, behind them. Pressured men to consume alcohol, Viagra, muscle relaxants, poppers, required the presence of staff during these events to ensure they couldn't leave. On more than one occasion, Eminem either directed others or personally injected men in their members with a prescription grade erection inducing substance for the purpose of causing the men to engage in acts in which they were otherwise physically incapable or unwilling. Notwithstanding the fact that these injections were not medically indicated and frequently caused the men to suffer painful physical reactions that lasted for several hours. Yeah, if it's Viagra, you certainly would have felt like your heart was going to explode. Jeffries and Smith employed their use to fulfill their own desires. On more than one occasion, Eminem engaged in acts, continued to engage in acts, or caused men to engage in acts, including but not limited to back pen and use of high-pressured enemas to which the men did not want and were unable to consent. So first count, that is the sex trafficking. This is on or about the dates that we talked about, 2008, 2015, both dates being approximate and inclusive, that they knowingly and intentionally recruited, enticed, harbored, transported, provide, obtained, and maintained by any means one or more persons in affecting interstate commerce, and did benefit financially and by receiving anything of value from participation in a venture which engaged in such acts, knowing and in reckless disregard of the fact that means of force, threats, or force, fraud, and coercion, and any combination of such means would be used to cause such person to engage in those commercial acts. I'm going to break that down. So I'm going to pull the elements of that offense. I already have it ready for you because you all are so lucky that you have me. So let's get into plain language. So basically, in order to be convicted of sex trafficking, the person, and I've pulled it, so we're going to really get into the weeds of this, that whoever knowingly or in effect, so they, if they did interstate or foreign commerce, so we already know that. So they recruited or enticed. We don't have to get into all of the extra words. So let's just say recruited, enticed, they transported these individuals or solicited it by any means, any person, or, and I don't think that this really wasn't an issue for them, but it's in the statute anyway. They benefit financially, or by receiving anything of value. So that would be like if they were pimping them out. And because there is the allegation that other men were involved, that may be why they included this section. And when I say other men, and maybe women, I don't know, I mean other individuals that were friends and associates of Eminem, Matthew and Michael, because at that point, if you are bringing other individuals into this scenario and essentially pimping them out, then you are getting a financial benefit from them as well. And more importantly, these individuals, in violation of the first part of the section, um, that there was a reckless disregard for them, or that there was force, threats of force, fraud, coercion. Coercion is big here. Um, and any combination of those things. So we are talking about potentially fraud. You're going there for one reason, and there's another. Coercion, of course, that's going to be a piece there as well. And there's also one here right now. There doesn't, at least that we know of, but they are charging under the statute. Whether or not there were any underage individuals, I do not believe there was. At least the prosecution didn't say it, but that is included in this act just in case. I think, and as of course we know that when it comes to sex trafficking, because there is that element of fraud and coercion, sometimes force, which of course would be the piece with that they talk about with the injections. There was a discussion of it, not here, but during the press conference, of other drugs that made the individuals, and even in the civil suit, other drugs that made the individuals woozy, perhaps GHB. And that's where I wanted to talk about the thing that was so insidious about the drugs, because you're giving someone a drug that potentially incapacitates or partially incapacitates them, so that, which makes them more pliable and more just in a better position for you to be able to do the things that you want to do to them. But then on the flip side of that, because you have rendered them into a position where, I'm just going to flat out say it, if you're dealing with a man in particular, they're not going to be able to perform. Their member is not standing at attention. Well, that's partially because of what you did to them to make them compliant. But then you want to actually have use of that part of their body as well. So then you inject them with another substance. And let's be clear, that is assaultive behavior. They're not charged with assault, but if that happened, that is also what that is. Now, there may be some statute issues in terms of them being charged with that. And of course, that's fine, because you have the force with that. Because at that point, if that's what you're doing in order to get me into a position, now you're taking me by force. Okay. So let's see. What else? Okay, so the punishment. The punishment, as we talked about, the punishment is 15 to life. And I say 15 to life because you have a mandatory minimum of 15 years. And it says imprisonment for 15 years. If the offense didn't fully happen, and the person, well, no, that's if they're underage, and right now it does not look like we have that, so that part is fine. There doesn't appear to be any obstruction or anything like that. So let's talk about coercion. So what's coercion under the law, particularly under this statute, mean? Coercion means threats of serious harm to or physical restraint against any person. Physical restraint, we're talking about possibility that they can't leave. Physical restraint, if you've given me drugs to incapacitate me, That's a restraint. If I can't get up because of something you've given me, I'm restrained. Coercion also, and this is important here, any scheme, plan, or pattern intended to cause a person to believe that failure to perform an act would result in, okay, so they also talk about result in serious harm to or physical restraint against any person. So we talked about that. The abuse or threatened abuse of law or the legal process. So, of course, we know the legal process, talk about NDAs and all of that stuff. But when we talk about coercion in this context, coercion could also, yes, they talk about threats of serious harm, but that harm or those threats could also be literally about their livelihood and their life. You're not going to have this. I'm taking it all away from you. I'm blackballing you. I'm doing all of that. So coercion goes even deeper than this. And we know because we see it in sexual harassment cases. The term commercial sex act means any act on the account of which anything of value is given to or received by any person. And so those are the individuals who knew that yes, we're going into this for sex. They still believed that there were other elements to it. And then, of course, we know that as can happen, what you agreed to isn't necessarily what happened. As in, I agreed that we're going to do a little slap and tickle. I didn't agree to, baby oil and, what do they call it? Pink cocaine or what? Well, no, that's cocaine and amphetamine. What do they call it? It's pink something. Anyway, it's Tussie, or it's Tussie. It's got a couple of different names to it. Okay, what else? Participation in a venture means knowingly assisting, supporting, or facilitating. Of course, that's Jacobson, where they'll say the term serious harm. Now, remember I mentioned serious harm in terms of coercion. This is important to understand because people are like, when you say serious harm, they automatically think, oh, well, nobody hit anybody. Serious harm is bigger than that. So serious harm within the framework of coercion is harm, whether physical or non-physical, including psychological, financial, or reputational harm that is sufficiently serious under all the surrounding circumstances. Surrounding circumstances here is, I want a job, I want a model, I want to be this, this is my life. And you are the person who could be the key to me getting it, or you could screw me and taking it away. You entice me by presenting yourself as the key to getting it. Then things go farther and I am potentially put in a situation to do even more because of you making sure that I never get it or taking it away. So it's sufficiently serious under all the surrounding circumstances to compel a reasonable person of the same background. So not what you or I think is reasonable. The reasonable person in that situation of the same background and in the same circumstances to perform or continue to perform commercial sexual activity in order to incur further harm. So a reasonable person similarly situated, not you sitting in your house listening to me or at your job or in your car. The term venture means any group of two or more individuals associated, in fact, whether or not they're a legal entity. Okay, then they've got 15 counts of interstate prostitution. So what is that? Whoever knowingly persuades, induces, entices, or coerces, there we go, but we also have the persuasion, inducement, any individual to travel in interstate or foreign commerce or in any territory in possession of the United States. And this, they did both. They were in other places in the United States and internationally, to engage in prostitution or in any sexual activity for which any person can be charged with a criminal offense or attempts to do so shall be fined under this title or imprisoned for not more than 20 years or both. So, sexual activity for which any person can be charged with a criminal offense. Now, that doesn't necessarily mean, now we have the prostitution piece, we don't. But sexual activity for a criminal offense could also be sex against someone's will. Again, that is going to be very important in terms of the pieces about the Viagra, the injections, all of that, because that makes the difference. If someone is just engaging in international prostitution, but everybody was good with it, nothing, no harm, no foul in terms of their physically something happening to them or anything like that. And yes, it was wrong because it's just illegal to do it, but the individuals didn't, I guess, weren't harmed. They didn't lose anything. Yes, they may have been persuaded and induced and enticed and all of that, but that sentencing is going to be veered towards the lower end because those individuals, they were all on the same page. But when you start talking about sexual activity for which the person can be charged with a criminal offense, because now we're talking about sexual assaultive type activity, then that's going to up the ante on that 20 years, because now we're not just talking about you engaging in international prostitution. We're also talking about the fact that you've potentially lied to individuals who may or may not have been willing, uh, given the information that they had, and you potentially harmed someone with assaultive activity or committed assault on them. And so that's going to up the ante in terms of the sentencing. So in order to be found guilty of that, the government has to approve, it has to prove these elements, specifically that the defendant knowingly transported the person, that the person was transported with the intent that they engage in prostitution, uh, and that if that activity occurred, that they would have been charged with a criminal offense under the laws of the United States. And that is why they know that, that's why they're not charged for every act, because they want to make sure that the most serious ones, where it's obvious that the person was just flim-flammed and or flat out assaulted. However, remember, the activity does not, and that's important, the activity does not have to actually take place. There just needs to be substantial steps towards towards it taking place. Typically, again, them getting there, perhaps money changing hands, etc. So, for instance, even from the model jury instructions, if they did something that was a substantial step towards committing the crime, and that corroborates the intent of the crime, not just preparation, but that you actually did something. It's like the bank robbery example that I like to use. You may not have actually robbed the bank. You may not have even gone in the bank. You might not have even made it out of the car when you pulled up to the bank, but there was substantial movement towards that. You did your planning. You had your tools. You got the mask. You did everything, and you pulled up to the bank. you were getting ready to rob it, that shows that those things are substantial steps towards doing it. Now, you didn't actually do it. In my bank robbery example, unless you're charged with conspiracy, you might be okay. But in the case of a conspiracy to rob the bank, you all had the meeting of the minds and you did some things in furtherance. So in this situation, you decided that you were going to do this. You did things in furtherance and you took substantial steps. So usually in a situation like this, it's everything but the sex, basically. You got them, you got the person there, money changed hands, etc. You just didn't go through with it. And you see that even in regular prostitution stings, having nothing to do with anything like this, just regular stuff. When you have undercover police officers, you also, and especially with my clients, you see it in drug cases where you have undercovers. The cop doesn't actually have to stand there with you and take the drugs and whatever. As soon as you make the deal and the money changes hands, you're good. The case is going forward. Money is changing hands. I'm giving you the money, you're giving, and you've got the drugs, you're there. Give me the exchange. Okay. So let's see. And even that is more than what's required here, because in that instance, the deal did actually take place. So really is more so. So I'll take that instance back because the deal did take place. But in prostitution stings, you make the deal, the cop pays the money, the sex doesn't have to happen. You're guilty of prostitution. Same thing when the cop is on the other end and they're trying to catch Johns, the person, the undercover prostitute has the conversation with the John. As soon as the John makes the deal and hands over the money, you've committed the act of solicitation. So or you're on the receiving end of the solicitation, actually. Okay, so there you go with that. You know what that means. So let's get back to the indictment. I just wanted to give you some important information. So you got the 16 counts. Criminal forfeiture as to count one. These are just making sure that under the code, you can take every ounce of money from that person if you can prove that in any way it helped to commit or facilitate the offense. So that means digging in those pockets, and you can argue that they should forfeit that money. So let's say they're talking about, that's why they specifically talked about the company. If that company was used as a means to effectuate this, if you were in any way using that company, then they're going to go get it. And they're going to say, oh, it's traceable to that property. It's traceable to the money. You used the money to pay individuals. And at that point, at that point, they're going to go after it. They're going to go after it. No, they're not going to take everything, but they're going to go after that money for sure. And also, if there's anybody that's identified as a victim, something might happen there, but that's where the forfeiture will come through. Same thing, criminal forfeiture, allegations 2 through 16, same thing. The government will seek forfeiture, which requires the forfeiture of any property, real or personal, that was used or intended to be used to commit or facilitate the commission of such offenses. And by any property, real or personal, constituting and derived from proceeds obtained directly or indirectly as a result of those offenses. And by the way, let's be clear, real or personal property, that means they could also come after the house. Oh, you use this house as your prostitution house, as your whorehouse, as your let's have our sex event house, then we're taking the house too. We're shutting you down. Okay. So that is it. It says it's a true bill. It's filed by Breon Price. I believe it's Breon, Breon. Breon Peace, I'm sorry, United States Attorney for the Eastern District of New York. So this is going to be an interesting case, folks. It's not as all of the allegations in this. Yes, they go back almost 10 years, about 15 years, 2004, so 14, 15 years when they started. But in this case, they are not having any problem with folks talking because these guys have been talking for years. I mean, like I said, there's been documentaries. You go on YouTube, you could even find all kinds of stuff about it. Now, the BBC special, you either have to have BBC or Prime Plus. I saw it years ago when it first came out, but it's hard to find on YouTube now. I think they scrubbed it to kind of get you to buy it. And it's only like an hour long because it was a part of a series of that the BBC has about a whole bunch of things, but one of the hour longs that they did as a part of that series was on Abercrombie. But again, lots of articles over the years, lots of exposés about this guy. There's nothing, well, yes, some of these details are new, but I'm saying nothing new in terms of it being alleged that Creepy McCreepster in this situation was just wilding out in these streets, or rather in fancy hotel rooms. So, as usual, I look forward to talking to you all about this case and many more. Like, comment, and subscribe. We do have another episode coming up that I can't wait to talk to you about. And that episode is called Blurred Lies and Cracked Alibis, where we're going to jump in and talk about some of the housewives and their latest criminal woes, particularly Karen Huger's case. I am actually in the DMV where they are. And of course, I've done so many DUIs throughout my career. I can't even begin to count them. So we'll definitely talk about that in the motion that was filed this week. And I think just, again, dispel some myths and misconceptions about that case. And again, so like I said, blurred lies and cracked alibis, because that cracked alibis part, we are going to talk about one of everybody's favorite topics, which is Love is Blind. This most recent season 7, particularly the person who's on everybody's tongue, Mr. Man with the babies that he claimed don't really exist. Or I guess they exist but aren't his. Well, we'll get into that again. Stay tuned for Blurred Lies and Cracked Alibis. Of course, we'll have roundup on the Diddy cases as well. And again, lots of fun stuff too, because when you do this kind of stuff, it can be as funny as it is crazy. And then also I like watching some of the same crazy shows and pop culture stuff and keeping up with all of that with you all. Like, follow, like, subscribe, comment. I've said that umpteen times for the folks on YouTube. If you are listening to this on the podcast, leave us 5 stars and comments wherever you are, and certainly follow on wherever you enjoy listening to your podcast. I really, really appreciate your support. If you want to support the show, in the description box, you will see the Cashapp and Venmo. Goes a long way when we're doing the research and all of this stuff, because those things take time and effort. And most importantly, as I always tell everyone, if you are thinking about it and want to talk about it, chances are I'm thinking about it and want to talk about it with you. So let's be honest together. Have a good night, and in this case, a good morning, because it is almost 3 a.m., but I love you all so much. I stayed up after my real job to do this as well. Good night.